This special meeting of the Judson Board of Trustees is hereby called to order at 5:01 PM. I am very pleased you have taken the time to join us this evening. In compliance with State Government Code on Open Meetings, tonight's agenda has been appropriately posted. These proceedings are being video and audio recorded and will become part of Judson's permanent legal record. In order that the tape adequately reflects these proceedings, please silence your mobile devices and refrain from talking while others are speaking. Once again, I extend to each of you a sincere welcome from the entire school board. Thank you for your interest in Judson ISD. We have established a quorum, and I will call roll. Okay. All right, we have 6 members present, and Ms. Canoyer is not present. All right, the board will now adjourn into closed session pursuant to the following sections of the Texas Open Meetings Act. Pursuant to Texas Government Code, Section 551.071, consultation with attorneys regarding legal issues pertaining to cause number 2026 CI 01608, Lisa Butler versus Judson ISD and Monica Ryan in the Bexar County District Court in the 166th Judicial District. Pursuant to Texas Government Code, Section 551.071, consultation with attorney regarding legal issues pertaining to cause number SA 26 CV 03285 OLG, Jose A. Macias Jr. versus Judson ISD et al. In the United States District Court, Western District Court of Texas. Pursuant to Texas Government Code Section 551.071, attorney consultation regarding legal issues related to the board-approved investigation of employees' complaints alleging discrimination, harassment, and retaliation under Judson ISD policies DIA Legal and DIA Local by trustee Jose A. Macias Jr. Pursuant to Texas Government Code Section 551.074, discussion of the board-approved investigation of employee complaints alleging discrimination, harassment, and retaliation under Judson ISD policies DIA Legal and DIA Local by trustee Jose A. Macias Jr. Pursuant to Texas Government Code Section 551.071, attorney consultation regarding legal issues related to trustee Jose A. Macias's noncompliance with the sanctions, restrictions, limitations, and corrective measures included in resolution of the Board of Trustees censuring trustee Jose A. Macias dated April 23, 2026, and temporary restraining orders issued by Bexar County District Court in the 73rd Judicial District. Pursuant to Texas Government Code Section 551.074, discussion of trustee Jose A. Macias's noncompliance with the sanctions, restrictions, limitations, and corrective measures included in resolution of the Board of Trustees censuring trustee Jose A. Macias dated April 23, 2026, and temporary restraining orders issued by Bexar County District Court in the 73rd Judicial District. Okay, make sure that was all of them. Okay, the time is now...
Ms. Ryan, in terms of procedures, I'm not going to be in there for the case involving me. Do you want to do that last, or you want to do that first and I come in, or?
We're going to follow the agenda order.
So you want, okay, come back in.
Correct.
And out.
Okay, and it's 5:04, and we are now in closed session. The board will now reconvene in open session. The time is 8:32 PM. No final action, decision, or vote was taken while the board was in closed session. Okay, we will proceed with our rest of our open agenda. On agenda item 4A, I move that we proceed as discussed in closed session. Do I have a second?
Second.
Okay, motion by Ms. Ryan, second by Mrs. Potteet. Hearing no discussion, we will proceed to vote. Okay, motion passes 4-1 with one abstention. All right, moving on to agenda item 4B. I move that we proceed as discussed in closed session. Do I have a second?
Second.
All right, motion by Ms. Ryan, second by Mrs. Potteet. Hold on, let me. All right, if no discussion.
Is this the federal case?
This is, ma'am. All right, if there's no discussion, we'll proceed to vote. Okay, motion passes 4-1 with one abstention. Okay, moving on to agenda item 4C. I move that we adopt the following resolution of the Board of Trustees, centering trustee Jose A. Macias. Whereas the Judson Independent School District is governed by a duly elected Board of Trustees charged under the Texas Education Code with the lawful, ethical, and effective governance of the district. And whereas Texas Education Code, Section 11.051 and 11.151 authorize the board to oversee management of the district and adopt rules necessary to carry out its duties. And whereas Judson ISD Board Policy DIA Local and DIA Legal and BBFB Legal establish standards of conduct requiring trustees to act ethically, lawfully, professionally, and in a manner that promotes effective governance. And whereas these standards prohibit, among other things, abuse of official capacity, misuse of official information, hostile work environment, retaliation, harassment, racism, and oppression. And whereas violations of these standards may subject a trustee to sanctions, including public censure and restrictions necessary to protect district operations, governance integrity, and student safety. And whereas the board finds that trustee Macias engaged in abuse of official capacity and official oppression. Such conduct appears to constitute potential criminal violations of Texas Penal Code, Section 36.03, coercion of a public servant, 39.02, abuse of official capacity, and 39.06, misuse of official information, for which the state might take action. Whereas the board finds that trustee Jose A. Macias engaged in conduct constituting hostile work environment, retaliation, harassment, racism, and oppression. Such conduct appears to constitute potential criminal violations of Texas Penal Code, Section 36.06, retaliation, and 39.03, oppression, for which the state might take action. Whereas the board finds that trustee Macias violated board policy and ethical standards, including but not limited to failure to act with honesty, professionalism, and respect, failure to uphold confidentiality obligations, engaging in harassment, retaliation, oppression, and creation of a hostile environment. Whereas the board finds that documented evidence supporting these findings includes but is not limited to social media posts, news articles, and public statements, district email communications, board meeting video recordings, executive session memoranda, and litigation filings. Whereas the board finds that such conduct undermines public trust in the district, disrupts effective governance, harms employees and trustees, compromises confidential and privileged information, and exposes the district to legal risk and liability. Now, therefore, be it resolved. Section 1, adoption of findings. The board adopts the foregoing recitals as findings of fact and incorporates them into this resolution for all purposes. Section 2, determination of misconduct. The board determines that trustee Jose A. Macias has engaged in a pattern of conduct that violates Texas law, including conduct constituting potential criminal violations of the Texas Penal Code, violates board policies and governance standards, constitutes abuse of official capacity, misuse of official information, hostile work environment, retaliation, harassment, racism, and oppression, compromises confidential and privileged information and harms the district's legal posture, and adversely impacts the board's ability to govern effectively. Section 3, sanctions and corrective measures. The board imposes the following sanctions and corrective measures. 1, a public censure. 2, mandatory completion of training regarding district policy DIA, employee treatment, harassment, and retaliation training within 90 days from the date of adoption of this resolution with proof of completion required. Ineligibility to serve in any board officer position, president, vice president, or secretary, for a period of 1 year from the date of adoption of this resolution. Prohibition from entering or being present on any property owned, leased, or controlled by the district, including but not limited to all school campuses, administrative offices, athletic and extracurricular facilities, any other district-owned or district-controlled premises. Further prohibition from participation as a board member in any district-sponsored, district-affiliated, or district-sanctioned events, regardless of location. This restriction does not apply to official meetings of the Board of Trustees or board workshops or legally authorized governance functions. This restriction will be in place for a period of 1 year from the date of adoption of this resolution. 5, prohibition from initiating contact or communication with district staff for a period of 1 year from the date of adoption of this resolution. This restriction does not apply to initiating contact or communication with either the superintendent or the board president or a constituent while conducting board business. Section 4, referral to law enforcement. The board authorizes a limited waiver of the attorney-client and work product privilege communications regarding the investigation report, documentation, and statements, and directs that the findings of this investigation and all supporting documents be referred to the appropriate law enforcement agency for review and any action deemed necessary, including review of potential criminal violations under Texas Penal Code, Sections 36.03, 39.02, 39.06, 36.06, and 39.03. Section 5, directive for future conduct. Trustee Macias is directed to comply with all applicable laws and board policies, refrain from harassing, retaliatory, or unlawful conduct, maintain strict confidentiality of closed session and privileged information, and conduct himself in a manner consistent with the duties of a public servant and trustee. Section 6, notice of further action. The board notifies Trustee Macias that continued violations may result in additional lawful action as permitted by board policy and Texas law. Okay, I'm done. All right, do I have a second?
Second.
All right. Long motion from Mrs. Ryan, second by Mrs. Poteet. Go ahead, Mr. Macias.
Yes, thank you.
Just real quick, I will remind everyone that this is a personnel matter, so please use discretion. Some of the information that we did discuss and is closed in here is still protected.
So obviously, I do not agree with this motion or the language. Many of these issues are still being played out in litigation. I will have my day in court, and it's now in federal court. I just obviously want the community to know that this will be resolved soon, and I did attempt to resolve this on May 22nd, and the Judson Board decided to kick it to federal court. And so that's why it has not yet been resolved. But it will be. I do believe that my rights are being infringed. I do believe I have a constitutional right to speak what is on my mind, and more importantly, an ethical responsibility to call out corruption when I see it. And essentially, that's why we're arguing in court. So I do look forward to that. But I will say one thing, and this is a very genuine remark that I'm making. I love Judson ISD. I've been reelected and served 5 terms. This is a district where my community has been very supportive of my work. I hate where we are. I hate this BS that's happening. And so, there's been an overture that it might be my time to just kind of resign and step away. I would say that I would be willing to resign because obviously I didn't join this to have such a toxic environment, but I would only do that if Ms. Ryan resigned as well. So I'm going to say to you, Ms. Ryan, if you submit your resignation, I'll submit my resignation as well. And then we can move forward as a district if I'm truly part of the problem. I certainly don't want to be here to be a part of the problem, But I will tell you, as long as I'm on this board, I'm going to hold every one of my colleagues accountable. And so continue with this charade. I don't agree with it, and I can't wait until I have my day in court.
Question.
Sorry, I didn't see your button pushed.
Oh, I didn't.
Go ahead.
Could you clarify the part of the motion? I don't know if you can find it, but initiating contact with other employees? Where was that?
Hold on. I will reread that one. You want me to reread that one section? It was the last.
It was just
It's
a
the last
sentence.
bullet on section 3.
Last bullet on section 3 just says,
Under sanctions and corrective measures.
conduct that undermines confidence. There was something about initiating contact with other
Can I see your
employees?
document, and I will flip to the right page for you, ma'am? That's the right one.
Do I have the right document?
No, this is the wrong one. Oh, I'm sorry, you don't, I'm sorry. That's the one we collected up because it had to be redacted. You do not have a copy of this. So I will reread it for you.
The initiate contact.
Correct. The last bullet on the sanctions and corrective measures was a prohibition from initiating contact or communication with district staff for a period of 1 year from the date of adoption of this resolution. This restriction does not apply to initiating contact or communication with either the superintendent or board president or a constituent while conducting board business.
Okay. So I just wanted to clarify that's what that was, which strikes me as such a huge overreach to say if there are 2 employees that are making a complaint against a person, I might understand saying you can't initiate contact with those 2. But to say you can't initiate contact with anybody in the district is interfering with relationships that Mr. Macias has developed in the district for the past 16 years. And they're saying, now, we're going to come between you and all your other relationships. And I don't even know where there's a legality for that. My concern with this whole thing is that the complaint by the employee originated from a statement made in closed session.
Employees. more than one.
Employees, a statement made in closed session that was obviously shared with the employee. So I have an issue with that seems to me to be out of line. It also concerns me, it just feels like a huge overreach, and again, we have a very long motion. It's reminiscent of what was done with Dr. Fields, and it's, the report itself is mostly impressions, it's mostly assumptions, opinions, and perceptions of people, and you're always going to get that from people. They'll have their perception of what was said and how it was said and the impact that it had. So I have to take that into account as well. I do also have to note that the board had an opportunity to resolve all this on May 22nd. The judge was ready to rule and asked both parties to negotiate, and Mr. Macias agreed to negotiate to drop the suit if he got his privileges back, and the board decided to go to federal court. So they decided to extend this process, and an additional cost as well, cost and time to the district.
I don't
To-
think we're not on that agenda item, ma'am. That was 4B. We're on 4C now. We're not talking about the court case.
No, it's just talking about the thing that led up to
No, ma'am,
his.
this censure has nothing to do with the court case, ma'am. This censure has nothing to do with the court case. That was 4B.
Okay, so the court case is addressing this.
No, the court
censure.
case that has to do with the censure from April 23rd. This is a new censure, ma'am, for new conduct.
Right, right.
Yeah, it has nothing to do with court.
So I'm just looking at the overall picture of the board, which I am disappointed that the conflict seems to be extended. But at any rate, I think that the penalties are onerous, and exaggerated, and I don't even know where the authority comes from to interfere with relationships with other employees in the entire district. So we will see what happens going forward.
Just like to say something really quick. I am very disheartened by some of the people on this board who are more upset about the results of an action versus an action being taken. Something was said, doesn't matter how it got back to that other individual, it did. The fact that we have people on this board who are more upset that this person found out versus the person who said and did these things. That is a little telling, Ms. Sanford, that you're not upset about the actual actions, you are just upset about it being found out and him being held accountable.
It was a free speech issue. He was expressing.
Absolutely not.
Yes, it was. We
It was-
disagree. We respectfully disagree.
Quick lesson on free speech, ma'am. You have free speech. I have free speech. That does not mean that there are not repercussions for the organizations that you are with. That does not mean that people can dislike what you say and say what they want to say.
Sure.
That does not mean it absolves you from any kind of punishments for what you're saying. It does not, especially if it's coming from an entity and not necessarily an individual. There is free speech, absolutely, but part of that free speech is accepting the consequences of what you're saying. And if what you are saying is blatantly false, then there will be consequences. There will be accountability. Sorry, I'd lost the word for a second. There will be accountability. And free speech does not protect you from accountability for your actions and what you've said. So yes, Mr. Macias, you absolutely have free speech to say what you would like to say, but you can't use that as a cover to absolve the actions that you've taken and to absolve the things that you've said and to absolve the harm that you caused. That is what the censure is for. That is what these restrictions are for. And again, it is very disheartening to hear that you are more upset that somebody found out versus somebody said something egregious and somebody did something egregious.
I'm going to concur. I feel like it's flashback Groundhog Day where there's a wagon of literal documents again, right? This isn't he said, she said, he said, whatever, whoever said. There are emails, printed screenshots, printed documents, witnesses, again. And it's like you can have evidence slapping some people in the face and they still just will pretend like it never happened. And not all speech is protected. You are not allowed to threaten people and you are not allowed to harass people. And you are not allowed to share information that is privileged or protected by law. Like, there's no absolute free speech in this country, and whoever's telling people that needs to go to law school, because that's not even true. And I feel like we owe an explanation to the public, because I know everyone is very confused, right? Because this looks like infighting, right? This looks like people going back and forth with each other. But let's be clear that that is not what this is. Our responsibility as trustees are not only be part of governing our district, but we have to ensure our employees can perform their jobs without fear of intimidation, retaliation, harassment, or threats. That's why we approve policy letters that forbid that behavior. After we reviewed witness testimony, documents, board meeting videos, actual emails, sworn statements from board members to the courts, and other evidence, the investigators concluded that Mr. Macias engaged in conduct that was threatening, retaliatory, harassing, and he misused confidential information. That is not up for dispute. They further concluded that this actually harmed our employees. It disrupted our governance, and it compromised our confidential information, and it exposed this district to risk. For me, this issue comes down to one simple question. What message do we send to our employees if we fail to act? We ask employees to report concerns when they see misconduct. We ask them to participate in investigations honestly and truthfully. We tell them that retaliation will not be tolerated. I've heard that said on this dais for 3 straight years. We tell them the district is committed to maintaining a workplace built on professionalism, respect, and integrity. These promises mean nothing if we're not even willing to enforce them when the conduct comes from our own elected officials. No employee should have to worry that raising a concern will result in public attacks on their character, their qualifications, their reputation, or their career. No employee should fear retaliation for participating in an investigation and being honest and truthful. No employee should have to choose between doing the right thing and having to protect themselves. This censure is not political disagreement of this board. This isn't board infighting, differing viewpoints, and it's definitely not about protected free speech. Free speech does not allow you to harass, intimidate, retaliate, misuse your position of public trust, and then disclose the information you got as an elected official. When speech becomes a tool for retaliation, coercion, and the release of confidential information, that has now crossed a line that no governing body can ignore. This censure is about protecting our employees. It is about reaffirming that no one, regardless of your title, position, or how many terms you've served on this board, is exempt from the standards of conduct we expect throughout our district. If we expect our teachers, principals, support staff, and administrators to follow our policies, act professionally, and treat others with respect, then we must hold ourselves to those same standards. If an employee had acted this way, the motion I would have placed on the floor tonight would have been to propose the termination of that employee. That is unfortunately not an option when trustees act like this. The only mechanism we have available to this board to protect our employees, uphold our ethical conduct, and maintain public trust is through a resolution of censure. And the evidence 100% spoke for itself. And if we send a message to our employees that they don't matter, that they can't even be protected by this board, that's a message I'm not willing to send. Any other discussion on this before we vote?
Yes, I have a rebuttal.
Okay, go ahead, Ms. Would anybody else need a first try? Hold on, I got to get everybody first try first. Nope, that's okay. All right, second try, Mr. Macias, go ahead.
So again, some of what you said, actually, I can agree with, accountability. But I will say that the punitive action that's taken place against me is because of my free speech. Don't get lost in trying to change the narrative that I'm trying to come after employees. That's not the goal. There was never an employee that was directly threatened. They like to put that narrative that there was not. So this is literally about the tyranny of the majority. You have 4 board members who are colluding. And I'm going to tell you what I've said over and over again. There was a walking quorum. There was things that were done to an employee in our district.
Sir, we have to stay on this agenda topic.
It is related because
Sir,
all your stuff was related to it.
Sir, this is your second reminder that walking quorums are not on the agenda for tonight.
It is my opinion,
No, sir.
and I'm adding.
Sir, we have to discuss the agenda.
You're interrupting my time.
I am interrupting you, sir, because that's what the chair does when you go off agenda.
I'm not off agenda.
Do you need the attorney to remind you that we have to stay on agenda?
No, you clearly had a prepared statement
Sir,
that
go
was not
back.
directly there, so let me
Sir,
get
go
to
back
it.
to the agenda, or we're going to move on to somebody else.
This
Do you have anything else
is an
related to this?
example of tyranny for trying to stop
I don't
my
think
free speech.
tyranny's on the agenda either.
No,
so.
but it's bottom line. This is why we're here. And we're here because there are punitive measures they're trying to implement that are not right. That's why, again, I took action to sue the district, because you have 4 board members that, again, don't
We're not
understand
discussing the lawsuit, sir.
I'm not.
I've already
I
reminded this
just-
board, we need to stay on the agenda topic, or this board will be in violation of the Open Meeting Act, sir, and I'm not going to participate in a meeting that is illegal. So I need you to
the
get back on the
action-
agenda topic, please.
The action that is here today is a result of all of that. So when Ms. Ryan is over there saying that we need to protect employees, I don't remember this being part of this too, but I'm not against harming employees. I will say again, Ms. Ryan, if you resign, I'll resign. And that's just it. If you love this district like you claim you do, then we'll both be submitting our resignation. But I do appreciate my community support, and I assure you, community, I'm going to stand firm here, because I'm also looking for the same thing they claim they're looking for, which is accountability, and I will get it. And lastly, we do have a future TEA investigation that will also help find the truth. So it's coming. I'm assuring you, we will see accountability.
All right, Ms. Stanford?
Yep,
You have
I
one more
just-
comment? If we could please stay on agenda, because that's about 17 times we've gone off this agenda topic, and we need to stay on agenda in order to be in compliance with the law, which I know some people aren't
No.
crazy about the law, but we got to stay in compliance with the law.
I don't think referring to something is actually discussing it, but
It
I
is,
do
ma'am.
want to say that the tone that's being set is retaliatory in itself. And it creates a gotcha environment that employees definitely hear about as well. If they see a board that's got a gotcha attitude, like we're going to get you for anything, and I wouldn't be surprised if a couple of us are next. So that concerns me for the message being sent to employees, because it's just disheartening when they see this happening. But there is coming a day in court, and we'll just see what the court says. You have to sometimes appeal to a higher authority.
Again, ma'am, this censure is not the subject of any active court case. So if you need to talk to legal counsel afterwards, and he can reiterate that to you, but this censure is not part of any legal court case. So I'm not sure
No,
why you're
I-
confused.
I'm not confused, and I made the point, this will all be resolved in court.
In court? Mm-hmm. Okay. Well, there's no court case on this, so we're fine. Okay. Yes, but just, I'll have my one closeout is, I'm sorry to all the employees out there, right? I'm sorry, because they're saying that it's okay to threaten you, and it's okay to retaliate against you. It's okay to intimidate you.
No one is
in
saying
order
that.
to-
No one is
Mr.
saying
Massey.
that. I did not say it's okay to do any of that. So please stop putting that narrative out there, because that's not true.
Okay, if you're not interrupting, thank you.
Well, and you didn't
as-
interrupt me, right? So,
You done? Okay. As
I
Ms.
think you
Sta-
should just proceed to vote already. I mean, I don't know why you're trying to take the narrative again, but you certainly didn't interrupt me and say you're off agenda, so I'll remind you the same thing. Just vote already.
You done, Mr. Macias?
I hope you're done.
Okay. And I hope one day we'll get professionalism back to this
I hope you
entire
just
board, I hope
resign.
So anyway, as I was saying, as Ms. Stanford was talking to some employees, I'm sorry to all the rest of them. It took some very brave souls throughout the last 5, 6, I'll be honest with you, over a year, risking themselves in a very retaliatory environment to come forward. And Judson would not be where they are today, having gone as far as we've gone. We're one of the few school districts in the state of Texas going to have a balanced budget. We are doing amazing things, and that's because our employees spoke up, and members of this board made sure that retaliation and threats were not going to be acceptable against them. And if that's, we got to walk the walk if we're going to talk the talk. And if we're going to be a retaliation-free district, then that starts at the top. Real easy. So, and the evidence speaks for itself in writing. So, all right, everybody's had, I think, 2 chances, so we'll proceed to vote. All right, motion passes 4-2. All right, hold on, let me switch papers and all that stuff. All right, sorry, we are moving on to agenda item 4D. I move that we adopt the following resolution of the Board of Trustees, finding trustee Jose A. Macias in non-compliance with the board-ordered corrective measures, governance directives, and court-imposed conditions. Whereas on April 23rd, 2026, the Board of Trustees adopted a resolution censuring trustee Jose A. Macias and imposing sanctions and corrective measures and directives intended to protect district operations, student welfare, employee relations, and the integrity of board governance. And whereas the board expressly directed trustee Macias to comply with all applicable laws, board policies, district protocols, visitor requirements, governance standards, and corrective measures imposed by the resolution. And whereas the resolution specifically required trustee Macias to attend no fewer than 1 monthly meeting with the board president and superintendent for a period of 1 year to review expectations, address concerns, and ensure compliance with board governance requirements. And whereas following adoption of the resolution, trustee Macias sought judicial intervention and obtained limited temporary injunctive relief. However, the court did not invalidate the board's findings of misconduct and instead imposed additional conditions governing trustee Macias's access to district property and activities while acting in his capacity as a trustee. And whereas the court specifically required trustee Macias to comply with district policies, visitor protocols, board policies, and governance requirements as conditions of such relief. And whereas the board has reviewed information, reports, district records, administrative documentation, and correspondence occurring after the adoption of the April 23rd resolution. And whereas the board finds that trustee Macias failed to comply with the mandatory monthly meeting requirement imposed by the resolution despite receiving notice and opportunity to coordinate such a meeting, and whereas the board finds that trustee Macias entered district facilities on numerous occasions during the period in which the court-imposed restrictions were in effect, and that information presented to the board raised substantial concerns regarding compliance with the limitations imposed by the court and the conditions under which temporary relief was granted. And whereas the board finds that trustee Macias requested that district administrators remove students from instructional settings during the school day in order to meet with or question such students concerning matters unrelated to any authority vested in an individual trustee under Texas law. And whereas the board finds that such conduct appears to constitute continued interference with campus administration, instructional operations, and district processes previously identified in the board's April 23rd, 2026 resolution. And whereas the Texas Education Code 11.151B provides that trustees possess authority only when acting collectively as a board, and that individual trustees possess no authority to direct employees, conduct independent investigations, supervise district operations, or compel administrative action absent authorization from the board acting as a body corporate. And whereas the board finds that the conduct occurring after the adoption of the resolution demonstrates continued disregard for governance requirements, board directives, district protocols, and corrective measures previously imposed by the board. Now, therefore, be it resolved that Section 1, adoption of findings. The board adopts the foregoing recitals as findings of fact and incorporates them into this resolution for all purposes. Section 2, finding of noncompliance. The board finds that trustee Jose A. Macias has failed to comply with the corrective measures imposed by the board's April 23rd resolution, 2026 resolution, and has engaged in conduct inconsistent with the Texas Education Code, Section 11.151B, Board Policy BAA Legal, applicable district visitor and campus access protocols, the Judson ISD Good Governance Handbook, directives and corrective measures imposed by the April 23rd, 2026 resolution, and the conditions imposed by the district court as a prerequisite to temporary judicial relief. Section 3, finding of governance violations. The board further finds that the conduct described herein demonstrates a continuing pattern of behavior involving disregard for board directives and governance requirements, failure to comply with corrective measures ordered by the board, interference with district administrative operations, attempts to exercise authority not granted to an individual trustee, disruption of instructional activities and campus operations, and conduct that undermines confidence in the board's governance processes and corrective actions. Section 4, sanctions and corrective measures. In light of trustee Macias's failure to comply with previously imposed corrective measures, the board imposes the following additional sanctions and directives. A formal finding of noncompliance with the April 23rd, 2026 resolution. Inability to serve in any board officer position, president, vice president, or secretary for 18 months from the date of adoption of this resolution. Prohibition from entering or being present on any property owned, leased, or controlled by the district, including but not limited to all school campuses, administrative offices, athletic and extracurricular facilities, any other district-owned or district-controlled premises, Further prohibition from participating as a board member in any district-sponsored, district-affiliated, or district-sanctioned event, regardless of location. This restriction does not apply to official meetings of the Board of Trustees or board workshops or legally authorized governance functions. This restriction will be in place for a period of 12 months from the date of adoption of this resolution. Requirement that if a temporary court order is in effect that allows temporary limited access to facilities, requests to visit a campus or attend an activity or function must be requested through the superintendent at least 3 business days before the visit, and the superintendent will have the opportunity to have a cabinet-level leader or board officer present for the visit, event, or function. Mandatory completion of 3 additional hours of Introduction to the Texas Education Code training within 60 days with proof of completion required. Requirement that any future meetings or communications with district personnel occur only for lawful governance purposes and in compliance with board policy and district administrative procedures. Written acknowledgement within 10 calendar days of this resolution affirming receipt of and intent to comply with all board directives, district policies, governance standards, and court-imposed conditions. Section 5, notice of potential future action. The board finds that the failure to comply with corrective measures imposed by the board constitutes an aggravating circumstance demonstrating that prior sanctions had not achieved their intended purpose. The board expressly reserves the right to consider any additional lawful action available under Texas law, board policy, court order, or future governance proceedings, should further violations occur. Section 6, referral. The board authorizes a limited waiver of the attorney-client and work product privilege communications regarding these findings and directs that the findings and all supporting documentation be referred to the appropriate law enforcement agency and appropriate state or federal court for review and any action deemed necessary, including a review of potential criminal violations. And I'm done.
Second.
Motion by Mrs. Ryan, second by, Miss Ryan, sorry, married myself off, and second by Ms. Potteet. Discussion, sorry, discussion on this item. Go ahead, Mr. Macias.
Yeah, this is just a continuance of violating my rights, and assure you that we will have this time to discuss it in court. I do want to make sure that individuals know that my work as a trustee will not stop. And despite Ms. Ryan's efforts to thwart my efforts to serve, I probably will serve more aggressively. Just because it's read in a lengthy motion doesn't mean it's true. And so a lot of words there. But again, having an opportunity to litigate this will definitely prove some clarity as we go forward. So, again, this is just the word that keeps coming up, just a tyranny of the majority. If you oppose what they're saying, they're going to come after you. And that is the wrong message. So I think, if anything, it's going to require that I be more defiant. And the reality is that we're going to be doing this for about 9 more months, but there will be an end to it.
Wow, that is extremely disturbing that you're now going to become more defiant, sir.
What
Wow.
you've done is pretty disturbing, too.
Okay. I'm going to explain this one also and my position on this, because again, our stakeholders are just very confused on why all of this is going on. This action is not about politics, personalities, or disagreements among board members. This is about trustee conduct and behavior. Based on Mr. Macias's conduct, not his speech, this board took action in April to protect our students by restricting access to our facilities after student safety was put at risk. After being allowed back on campuses for a short amount of time under stringent restrictions, Mr. Macias didn't just refuse to follow those additional restrictions, his behavior escalated, with him acting in a way that I believe was even worse than the original behavior that led to the original censure. Behavior that has impacted our student welfare, campus operations, and interfered with parental rights. As a parent, if I found out that a board member had attempted to pull my child out of class without my permission during a school day to question her about something, or even worse, that a board member had actually successfully directed an administrator to pull a child from class, question her, take photos with her, and then post those photos of her on his personal Facebook page. And this school board knew about it and did nothing, I would be at that microphone losing my mind every single meeting from now until eternity. If anyone on that board had done that to my child. Parents in this district should be outraged.
You know I had
need
permission,
to
right?
understand what.
You know, Ms. Ryan, I had permission. There was nothing
You did not, sir.
sinister of what you
Oh,
said.
did you get permission just now? Because we were in closed session, you didn't have permission, so.
I had permission.
Okay, sir. Never mind.
But again, you're reading another
Sir,
prepared
you're
statement.
interrupting me, sir?
You're reading a prepared statement
sir. I'm
for
allowed to.
theatrical purposes because all what you're saying is inaccurate.
Okay. Sir, all of it is, again, in the binders in the wagon, if you'd like to go back. But when we sat in closed session, you wouldn't even open any of the documents the last 3 meetings to even look at the
Because
evidence.
this is in
So you wouldn't
court
know what's
right
in there,
now,
sir.
Ms. Ryan. All
All
this
right.
is in litigation.
I'm going to finish what I was saying, sir, because I do have the microphone for my 5 minutes. So if you could restart my clock, ma'am. Parents in the district need to understand what happened and how their children were put at risk. It is documented by our principals that he did this on more than one occasion in May. And I applaud the principals who were brave enough to come forward, especially against a board member who's been retaliating against people.
I have not been retaliating.
While this board has important duties to improve student outcomes, there is no duty more important than protecting our students while they are in our care on our campuses. Public office does not exempt anyone from accountability. In fact, it demands a higher standard of accountability. For too long, this district has struggled with a culture where certain behaviors were ignored or excused, and it usually depended on who you are. And if we expect accountability from our employees, our administrators, and our superintendent, then we must be willing to hold ourselves accountable as well. If this board does nothing, then it means it is supporting and condoning this behavior. And that sends a very dangerous message to every parent in this district. Protecting students is clearly then not our priority. Despite what I heard from 2 board members testifying in open court last month, the measure of a trustee is not how many photo opportunities you can take, how popular you are, or how many times you get reelected. The measure of a trustee is whether they're able to put the welfare of the students above all else and make the hard decisions, even when it brings heat upon us. Tonight, I'm voting in favor of this censure because failing to act would be a deliberate choice to excuse the conduct that put our children at risk and put our administrators in positions where board members were directing the operations of a campus and telling our administrators what to do. And that is well documented if you had opened the binder, Mr. Macias. And I refuse to tell our community that accountability depends not on what was done, but on who did it, and some people are exempt from accountability. And I won't send that message to the parents, the employees, and the taxpayers out in our community. So those are the facts as presented in a giant wagon. Any other discussion of this? Or anybody else want to dispute the facts? No?
I understand that you were functioning under legal counsel, correct, Mr. Macias?
That is correct.
No, you were not functioning under, you never contacted our board, our district's legal counsel? And,
Advised by my legal counsel, I didn't say Judson's counsel. I was operating as a
oh,
public
he
official.
told you you could go to Judson High School and pull 3 kids out of class?
Did I pull them?
I would get new legal
No, I did
counsel,
not
sir.
pull 3 kids. And
You requested
you're
to.
exaggerating the truth again.
Sir, you requested
So let
to.
me
Okay.
clarify, because Ms. Ryan likes to kind of tell half-truths.
Sir, I have a
You-
document from a principal. Are you calling that principal a liar? Because he might be watching this
Let me
video
ask you,
tonight.
did I pull 3 students out? Yes or no?
You
Did
asked
I
the
pull 3
principal-
students
Okay.
out? Yes or no? I did not.
We're good. The evidence
I
speaks
did
for itself,
not
folks.
pull 3 students out. So just because Ms. Ryan likes to be theatrical, I'll tell my community, there was an incident where our kids protested for immigration issues. And in that immigration issue protest, I took a picture with them. I was supporting their civic engagement. And of course, these pictures were posted. There was a lot of heat because the issue is controversial, but there was also a misspelling on the sign. And these kids were bashed by community members to a degree that they did not deserve. I wanted to talk to them to tell them to keep their head up, to keep themselves focused on civic engagement, and I asked if there was a possibility to pass that message on to them, either directly or through their parents. I talked with Dr. Jacklish, and eventually I agreed with him that I might need to do this in a different manner. There is no time any danger to student safety as they're trying to paint the picture. So my community is wise. They know what's going on. This is 120% political. And because she has 4 votes, we're proceeding in this manner that is harassing and intimidating. But I promise you, Ms. Ryan, I'm not going anywhere. I'm going to hold you accountable. I'm going to be right here. Unless you decide to resign, then I'll resign with you.
Yeah, I think that sends a very important message. Hey, I see a couple parents in the front row. By the way, Mr. Macias just said he's allowed to go pull your kid out of class.
I
So,
did not
just so
say
you know
that, Ms. Ryan. Again, you're putting words in my mouth, and I would never do that unless there
As long
was
as parents
consent.
are aware of that in this district, so.
That is
but
not what
I
I've,
think the board's
in
going to take action,
16 years,
sir,
I've
to
not
protect
done
the
that.
kids.
So you stop
Correct.
spreading misinformation.
Correct,
That is
sir.
really what you like to do.
Luckily, we have board members who are willing to do the hard things to protect students.
You have board members willing to play
And to protect our
politics.
staff, sir.
Just proceed to
Oh,
vote.
no. I know. The evidence speaks for itself. It is what it is.
It does not
So,
speak for itself.
It's in the wagon if you need to see it after the meeting.
There is no wagon, but go
There's
ahead.
literally a wagon.
It's not all related to this grievance.
All right. All right. We'll proceed to vote. All right. Motion passes 4-2. There being no further business, this meeting is adjourned at 9:18 PM.